Welcome to the Compliance Counsel on Command webinar series. Today's topic is the Bank Secrecy Act and OFAC Basics. I'm Jeff Anderson. I'm an attorney at the Dickinson law firm that works with community banks with a focus on regulatory compliance. The Bank Secrecy Act, or BSA, is not just one statute. It's really a collection of statutes that are commonly referred to under that BSA umbrella. So it includes the Money Laundering Control Act, anti-drug abuse, currency, foreign transaction reporting, most recently the USA Patriot Act, which was signed into law under the Bush administration. All of these laws together share the goal of keeping money from criminal proceeds out of the financial system. So your bank is, in a way, a gatekeeper. You're not required to enforce any laws. You're not going to be necessarily liable if somebody gets through your gate and introduces criminal proceeds through your bank. You're required to report and monitor. You're required to act as that gatekeeper and act in that monitoring capacity to notify law enforcement officials when there's suspicious activity or when there's large dollar transactions, so that ultimately law enforcement officials have more tools and can better track and prosecute crimes. BSA is one of the most burdensome regulations that banks face. I mean, in survey, banks consistently rate BSA as the most burdensome. It's a regulation you deal with every day. It takes time of your staff members every single day. Until recently, I mean, probably the only competitor now is the CFPB's mortgage rules. Prior to that, BSA was, bar none, the most burdensome, but it at least has a very laudable purpose. Not that other consumer protection-oriented regulations don't have a laudable purpose, but BSA, you can really think of it, you're safeguarding your community. The people that utilize your bank are your community members. Those are the people you want to protect. You want to keep that money from crimes out of your bank and out of the financial system. I like to start BSA presentations off with a couple of scared straight slides. So I'll talk about the penalties for noncompliance before we get into really the key pillars of a BSA program. BSA is a regulation where you do see a lot of high dollar amount civil money penalties for violations. Regulators take it very seriously. You can have violations that are just standard negligence. Once you get a pattern of negligence or gross negligence, that really ramps things up. In another presentation, I have another out there that's a BSA update where I discuss some recent enforcement actions. In that you'll see actions against JP Morgan and Citibank. They can get up to the hundreds of millions of dollars for BSA violations. If you have a pattern of noncompliance or just you're recklessly ignoring the BSA rules, that's where you get the high dollar amount violations. And an important thing with noncompliance is individuals can be liable too. So employees and board members can clearly be liable for intentional noncompliance. Just blatantly knowing the regulation and not complying with it, you can be held personally liable for that. When you have criminal willful noncompliance, you can have board members and individual employees get jail time and other penalties for that. It can be a very big deal. And we've heard statements from regulators. The OCC just came out with a speech recently where they discussed BSA risk, and they're really ramping up the enforcement of BSA against board members and against senior management. There's a high expectation on the board and senior management to ensure that the BSA program is strong and that the pillars we're talking about today are all very sound. But BSA violations also bring a lot of bad publicity. I think BSA and fair lending are the two areas that you can take the biggest publicity hit for violations. So again, if you want, if you're not scared enough, go out and listen to the BSA update where I'll talk about some recent enforcement actions. You'll get a better idea of the types of things, particularly with the larger banks, that they've gotten zinged on in their BSA violations. So we're going to talk about, this is just a basics presentation. We're going to talk about the basics of a strong BSA program. And BSA programs all start with a risk assessment. You have to assess the risks of the products, services you offer, of your customers, and of your geographic locations. The frustrating part when people have questions with BSA is any answer they get, and you'll get this answer from any advisor you talk to, it's going to be paired along with, well, you have to look at your risk assessment. And that's not just, sneaking around giving a meaningful answer. It's true. BSA risk assessment is the foundation on which the pillars of the program lay. You can't have a strong BSA program without a strong risk assessment. And the goal of that risk assessment is to rate all of those products so you can mitigate and identify those risks most efficiently. So you have some high-risk products and services potentially. We'll talk about some high-risk ones that have been identified by regulators. You could have moderate and low. And your approach, depending on that rating, could be completely different. If you have a high-risk borrower, maybe it's a borrower, a business that deals with a lot of cash, very cash-intensive business, you might have extra controls in place for those borrowers than you do for a very low-risk product or a low-risk customer. Examples of higher-risk products and services: electronic funds transfers, online banking, monetary instruments. It likely isn't news to you. It's those things that criminals are most likely to use, the things that are easiest to shift money around without being detected. Certain geographic locations can be a higher-risk area. There's high-intensity drug trafficking areas and high-intensity financial crime areas. So in Iowa, we don't have any high-intensity financial crime areas right now. Those are usually located in New York, Chicago, places where there's some type of exchange, monetary or commodities exchanges, and Florida, areas where there is a high migrant population and the possibility of people coming over internationally, a higher possibility. We do have high drug trafficking areas in Iowa, though. The links I provided out here, you can go out and look and see where those high-intensity financial crimes and high-intensity drug trafficking areas are. Certain customers can be a higher BSA risk. Your cash-intensive customers, money service businesses, casinos, dealers in metals, pawn shops, they can be a higher risk. Any business customers that have accounts in foreign countries or that deal with foreign individuals, that can be a higher risk. Liquor stores, convenience stores, attorneys, doctors, doctors and attorneys, you think, well, why would they be higher risks? Well, doctors, you have a risk of prescription drugs and fraud, and attorneys, there's a lot of risk there with their clientele and the handling of their trust accounts. So those are higher risk customers that you may need to pay more attention to in the BSA area than just a standard business, a mom and pop antique store. That's not likely to be a high risk customer, like someone dealing in precious stones. Or right now, think if you had a business that came into your bank that wanted to deal in Bitcoin. I'm not doing risk assessments for you, but I'd be pretty surprised if you did a risk assessment and that business wasn't rated a high risk, right? But someone that comes in and wants to start a antique shop store, that's going to be a bit different than the Bitcoin store, right? That's going to be a bit of a lower risk as opposed to the high risk of the Bitcoin. So you do risk assessments, and you do it on an ongoing basis. You're always changing your products and services. You're opening new branches. You're closing branches. You're acquiring new customers. You have to do that risk assessment throughout all of those changes. Generally, risk assessments should be done every 12 to 18 months. Regulators really like things on an annual basis, so if you want to do it 18 months, just document the rationale for that. So you have the foundation. That's the risk assessment. You've done the risk assessment. Now you know where are your high-risk areas, where are your low-risk areas, where should you spend the most time and the highest scrutiny and the most dollars on the higher risk and moderate risk areas, right? Now, from that foundation, you build up your BSA compliance program. So I think of a BSA compliance program as comprised of 5 pillars. You have internal controls. That's really the meat and potatoes of BSA compliance. That's where we'll talk about suspicious activity reports and currency transaction reports. Customer identification programs. That's ensuring that you know who your customers are. Training, ensuring that everybody who has any nexus with BSA within the bank gets training on it. And there are very few employees of a bank that have zero nexus with BSA. It touches almost everything within the bank. Board members need BSA trainings. Tellers need BSA trainings. Everybody in between needs some BSA training. Another pillar is you have to have a BSA compliance officer, somebody that really steers the ship of BSA. And finally, independent testing of your entire program. We'll talk about those individually. Your customer identification program, CIP, this was part of the USA Patriot Act. So this is one of the newer additions to BSA. And it requires you to have minimum standards to verify the identity of your customers when they open an account. That can be a deposit or a loan account, any account. You have to have a reasonable belief that you know the true identity of your bank's customers. So these are the 4 items that are explicitly required by the CIP regs. You need to collect the name, date of birth for an individual, the physical address, it can't be a P.O. box, and the identification number of your customer. Identification number, so where do you get that from? You can get it from various sources. The common ones are Social Security numbers, ITINs, EINs for businesses. When you have a non-U.S. person customer, you can use a TIN, a passport number, an alien identification card number. Other documents you can use an unexpired form of any government-issued ID. For businesses or trusts, they're not going to have, you can get the EIN number, but they're not going to have an ID. You can get the document showing their legal existence, their articles of incorporation and filing that shows they're in good standing with the Secretary of State. Other common forms of ID, driver's license, military ID cards, passports, student IDs, any of that can qualify. You just really need to ensure that the staff members at the bank, and that if you are a staff member, that you understand what forms of identification you accept at your bank, and that you know what to look for to ensure that it's not a forged document, and to ensure that it's not expired. So name, date of birth, address, ID number. Those are the bare minimum requirements. But additional due diligence is increasingly being looked at by regulators. So they're studying right now customer due diligence and ways to ramp up due diligence and require additional due diligence for banks. The purpose of doing due diligence beyond just name, date of birth is to be able to predict what types of transactions the customer is likely to engage in. Why would you want to know that? If you know what the customer is likely to engage in, you're going to be able to identify things that are suspicious better. You're going to be able to better protect the bank and better keep money out of the financial system that shouldn't be in there. Now, additional due diligence it's not part of the required regulation. It's just really part of guidance and strongly recommended, particularly for those higher risk accounts. So additional due diligence is where that risk assessment really comes into play. You got a higher risk account, that's where you really need to look at doing additional due diligence. Common types of additional information: credit checks, verification of employment, proof of address, previous banking references. Those would primarily be for individual customers. For business customers, there's certificate of organization, proof of EIN. I always recommend you get a resolution of authority, or whatever it may be called, depending on if they're an LLC or a corporation. But a document, an official document from the entity that states who's authorized to transact on that account. If you have that document, when somebody comes in and wants to engage in some transaction, you can pull that document up, and if they're on the list, you can do it, and if they're not, you can turn them away. If you don't have that document, it just leaves a lot of unknown out there and can, cause a lot of uncertainty for your staff members and how to deal with those business members. You have those high-risk accounts, you can go even beyond those official documents. What's the purpose? What's the source of funds of this account? Who's the beneficial owner? Banking references, domicile of the business, description of the customer's primary business, explanations for major changes in their account activity. These are all things that you can gather. You can gather these information and document it, and it might give you a better idea of, particularly for high-risk accounts, when you should be filing a suspicious activity report. So that's the customer identification program. The next of the 5 pillars is independent testing. This is a risk-based audit generally done every year, could go out to 18 months, and it's really having someone independent of the BSA process. It could be internal audit within your bank. It could be an outside audit firm that comes in and does a BSA audit. But they look at your program. They test your files. They look at how you're opening accounts and figure out, particularly with regard to the higher risk accounts, are you complying with the rule? Do you have any gaps? Are you filling out your SARs, your suspicious activity reports correctly? Are you continuing to do risk assessments? Okay. Now, these independent tests, they report directly to the bank's board of directors. Like everything, all authority from the bank flows from the board of directors. But BSA is identified by regulators as so integral and important that there's more direct channels plugged into the board with BSA. Your BSA officer is directly appointed by the board, and your independent tests are directly reported to the board. That BSA officer, so they're designated by the board of directors. They have to have the expertise and authority and the time that they need to be able to carry out their duties. So your BSA officer, particularly if you're not a larger bank, probably going to have other duties. It's not a full-time job, but they have to, those other duties can't subsume their duties as a BSA officer. They have to have the time to be able to devote to their BSA duties. They have to have the training that is requisite for a BSA officer, and they have to be given appropriate authority to be able to act as a BSA officer. And all of that flows from the board of directors. So the board is responsible for ensuring that that BSA officer has the expertise, authority, and time that they need. So if you have a BSA breakdown, the BSA officer could be at fault for it and could be identified by examiners as one of the causes. But if that BSA officer didn't have the tools that they needed, then examiners are going to go to the board and say, why didn't you give that BSA officer the tools that they need? It's really important that everybody in the bank knows who the BSA officer is, because BSA issues can arise almost anywhere. Suspicious activity can arise anywhere within your bank, and everybody needs to know who to go to with those issues. Everybody doesn't need to know the ins and outs of the Bank Secrecy Act. The BSA officer likely does, but everybody needs to know who to go to when they see suspicious activity or see an issue. Training, another pillar. Anyone whose duties require any knowledge of BSA is required to get training. Now, it can vary depending on the job role. Your BSA officer is likely going to need pretty in-depth training on at least an annual basis. Your board, on the other hand, they need to have knowledge of Bank Secrecy Act and updates, but they don't need the in-depth knowledge that the BSA officer does. They just need to be informed generally on an annual basis, at least, of changes and major developments in the regulations so that they know essentially what the board needs. They need the information that would be required in order for them to make decisions about what resources and staff to assign to BSA. So the BSA officer, even though their job duty flows from the board, they can be a part of informing the board of their duties and ensuring that the board knows about these changes so that they know when more training or more resources need to be devoted. It's very important to document this training. It's a real easy thing for regulators to write up. And they have to look for something, and this is just an easy one. If you haven't recorded that everybody's attended BSA training, then that's going to be something you get a check mark on. So make sure that you're retaining the training materials and tracking attendance and ensuring that everybody's getting ongoing periodic BSA training. Now we're to the internal controls of the BSA program. The first is CTRs, currency transaction reports. These are filed when you have transactions that in the aggregate in one day are more than $10,000 by or on behalf of the same person. So you aggregate all transactions in one day, but only within the type of transaction. So if I come in and I make a $11,000 deposit, that's a CTR filing. If I come in the morning and I deposit $5,000, then I come in at 4 o'clock and I deposit $6,000. Add it together, it's $11,000. You file a CTR. Same for withdrawals. Same would be true of withdrawals. But if I come in the morning and I deposit $5,000, but then I come in the afternoon and I withdraw $6,000, you don't add those together. You only aggregate together deposits and withdrawals respectively. You're tracking, you're verifying and recording the name and address of the customer that is presenting the transaction and will be ultimately reportable on the CTR. The existence of CTRs and the fact that you're filing them, I don't think you necessarily want to advertise it and tell people that you are, but it's not confidential like SARs are, like we'll talk about. So if I come in and, I make, this is my third deposit of the day, and this one's going to add up to $11,000, and I ask, will anything be filed on this that will be sent to the feds? You can say yes. You can tell them. You wouldn't be able to in the SAR environment, but you can say, yes, we're going to file a currency transaction report. It's not confidential. Now, then, when I, at that point, say, oh, you know what, I'm just going to deposit this tomorrow then. Well, now I'm structuring, right? Now you have the enough evidence to file a suspicious activity report. And now I've been notified that a CTR is going to be filed, and it's a little suspicious that I'm structuring my transaction in a way so that one will not be. I'm trying to evade detection. So in certain instances, people structuring transactions to avoid CTRs can lead to a suspicious activity report filing, which we'll talk about. This is what a SAR looks like. So on the left side of the screen there is the old paper suspicious activity report. Now both SARs and CTRs have both gone electronic. And really, in my experience, that went pretty smoothly. So, as you all are familiar with, there are often problems with government websites. And there weren't really that many with the SARs and CTRs. I mean, there were a few hiccups, Some banks had a few problems, but overall, the transition from paper to electronic went far better than I ever thought it would. It went very well, I thought. So suspicious activity reports, what are common reasons for filing a SAR? Structuring, that's what I just talked about. Batching transactions in a way to evade detection. Check fraud, computer intrusions, credit debit card fraud, identity theft, mortgage loan fraud, wire transfer fraud. Any illegal activity. Any illegal or suspicious activity can be the grounds for filing a suspicious activity report. In certain instances, you're required to file a SAR. If you have any criminal violation that involves insider abuse, that involves an employee of the bank, even if it's a small dollar amount, it requires filing a SAR. If you have criminal violations with an outsider, someone outside the bank, that aggregate more than $5,000, and you have a suspect, you have a person that you know is engaging in these transactions, you don't need to know that it's illegal. It's just suspicious. There's a suspicion of criminal activity. Then you file a SAR. So if you have an actual criminal violation, you're required to. An actual criminal violation of $5,000 or more. A criminal violation of $25,000 or more, even if you can't identify a potential suspect, you're required to file a SAR. This is the regulatory language that lays that out. The last bullet I'll highlight. You need to file a SAR anytime there's a transaction that has no apparent business or lawful purpose. So this is where that additional due diligence can be of big assistance. You may not always know if it has no business purpose unless you know the customer's business and what they're doing. Yeah, I mean, if there's a $25,000 withdrawal, for some businesses that could be perfectly normal. For others, that could be way outside of the realm of what they should be doing. So, engaging in that additional due diligence can really help with that third bullet and identifying if there's no business or lawful purpose. So there's a lot of leeway between when is a SAR required to be filed and, when else should it be. There are many instances where you can file a SAR where it's maybe not mandatory. Anytime anything is suspicious, anytime you're suspicious of criminal activity, it can be the grounds for filing a SAR. So that you get a safe harbor. You're never going to be liable for filing a SAR. Most suspicious activity reports that are filed have nothing to do with criminal activity. They're perfectly innocent transactions. And you file 100 SARs, maybe the majority of them are perfectly innocent or don't even ever get investigated by the feds. That is not your problem. You're not on the hook for any of that, okay? You file a SAR, you're not liable for disclosing that or for failing to provide notice of that disclosure to anybody. You get an absolute safe harbor from any civil liability. When do you file the SAR? You file them no later than 30 calendar days from the date of initial detection when you have a suspect. If there is no suspect, there's no person to file it on, it's 60 days. So that timing starts, that initial detection, it doesn't start the moment that the transaction occurs. The 30 days doesn't begin to run until your SAR escalation process has worked its way through. The 30 days begins to run once a transaction has been flagged by your bank, likely by your BSA officer or by your BSA committee as suspicious. After that, you have 30 days to file it. So your duty as a bank is to just notify and file the SAR that something's suspicious. You're not a law enforcement agency. You're not required to investigate it any further. And I bring this up because I've talked to financial institutions. I remember I talked to one that they were located close to D.C., and they actually had somebody come in and from a law enforcement agency. A lot of their customer base was law enforcement. They actually had somebody come in and, congratulate them on the depth of their suspicious activity reports. And this was at a seminar where this was discussed. And come to find out that the employee that was charged with filing SARs, they were going online and doing research, looking at people's Facebook and Googles, and going into courts online to figure out their records, and including all of that with the SAR. I guess you can. You're not violating anything by doing that, but that's a lot of wheel turning and wasted time. That's not your job at all. There's no expectation that you do anything that extensive. Now, that's not to say that the quality of the SAR isn't important. It's very important to include a detailed narrative, but you only need to include in that narrative the information that you have available. So you include who, what, when, where, why, how. If you can answer all those questions in your SAR narrative, you have a quality SAR at that point. You've done a good job. Very important is the confidentiality of SARs. The fact that you filed the SAR and the existence and content of the suspicious activity report are strictly confidential. The way to think of it is that suspicious activity report, maybe it's printed on your paper, maybe it resides in your servers, but it's not yours. It doesn't belong to you, so you can't tell anybody about it or about what's in it. The only certain appropriate government agencies can access that suspicious activity report. Generally, your law enforcement agencies, Attorney General, Secret Service, any of those listed there, and there may be a few others, not an exhaustive list. But if you ever have any questions about someone came in and asked for a copy of a SAR, can we provide it to them? You can call FinCEN. It's their document. Call them and ask them if you have any questions about that at all, or call your legal counsel and have them reach out to FinCEN or answer the question if they can. What we've seen before is we've seen requests for suspicious activity reports in the discovery phase of litigation. And you might get a subpoena that purports to require you to provide a suspicious activity report. Well, the Polk County District Court is not on that appropriate list right here. So unless one of those agencies is requesting it, you're the plaintiff that's suing you. They can't get a copy of that SAR. They have no right to it at all. You can't even tell them that it exists. So if you're responding to a discovery request from a plaintiff and they request a suspicious activity report, you don't even acknowledge that it exists. You craft a response that, essentially says, we don't even acknowledge the existence of any of these documents. Even if one did exist, we wouldn't even be able to provide it to you. So how do you keep SARs confidential? How do you keep any secret confidential? You tell the least amount of people. The less people that know about the existence of a suspicious activity report, the more likely the confidentiality is going to be kept. And in smaller communities, this can be a challenge because you have smaller offices, and people may walk by and see something. Your computer system may be easily accessible. So, limit access to these. Restrict the folders that they're in if they're out on a network or if they're in paper. Lock those up and ensure that everybody can't see them, because particularly in smaller communities, that's where information about the filing can get out. I mean, everybody knows everybody, and you see that a SAR is filed on your neighbor, you might start talking about it. Before we move on to the use of CTRs and SARs, just one kind of anecdotal example of, I get questions sometimes about, should we file a SAR? This happened, should we file a SAR? And 9 times out of 10, if somebody's calling me with the question, then it's probably risen to the level of being suspicious, and they should err on the file of filing it. That's not to say you should file 1 million SARs about every single thing, but one example was I've gotten a call before of someone deposited $4,000. It's not a CTR, but the money reeked of marijuana. Should I file a SAR? Well, it's suspicious of illegal activity, right? I mean, I suppose it could be sage or something else or some type of incense that only happens to smell like marijuana, but you're not verifying the criminal activity. You're just verifying it's suspicious. So, I mean, yeah, that's suspicious. I'd say file it. So you're filing all of these CTRs and SARs. Is anyone even looking at these things? It's such a high burden. Yes, they are. And I've been to a presentation where FinCEN spoke, and they have staff that reviews all the SAR filings, and there are hundreds of thousands of filings a year from banks, credit unions, casinos, money service businesses. So they're reviewing them all. Every one doesn't trigger an investigation, but they're all reviewed by a person. And they're used for a tip-off, starting a criminal investigation. Something suspicious, it could trigger an investigation. They're used for identifying criminals. And criminals move around and they put money in and take money out of the financial systems in different areas. And many times when law enforcement agencies are trying to build a case, they have a lot of gaps, time gaps, where they don't know where a criminal was or what happened. Some of these can fill those gaps in. Outside of individual prosecutions, they can be used to identify trends. Law enforcement officials can use these filings to say, we're having a high amount of drug-related SARs in the Cedar Rapids area. I'm not picking on Cedar Rapids for any particular reason, just in one particular area. Maybe we need to allocate some more resources out there. Maybe we need to spend some more time there. And they can be used just generally for deterrence. Just the existence of these CTRs and SARs deters some criminals from trying to use the financial system. Now, your sophisticated criminals, they're always going to figure out some way to get the money in and to move it around. That doesn't mean we should make it easy. And, your lower level criminals, they might not want to do it at all because they don't have the sophistication to be able to get it in. So just the existence of these mechanisms can be a significant deterrent. Do they work? There are hundreds of thousands filed, like I said, and so these numbers from 2012 of 1,600 investigations started and 800 sentences. If you're looking percentage-wise, almost 1 million SARs filed and, 1,000 people sentenced, it may not seem like a high percentage, but that's 800 people sentenced to, on average, 5 years that are off the streets where that money laundering investigation, that SAR was a big part of that prosecution. So that's significant. Others, BSA investigations outside of money laundering, 300-400 sentenced in 2012. These are all on the rise, too. And so these are significant numbers. If you take a percentage, maybe it looks small, but that's a lot of criminals that are off the street that are really due to your work on Bank Secrecy Act compliance. Briefly, I want to touch on OFAC as well, the Office of Foreign Assets Controls, because it often goes hand in hand with BSA. At many banks, your BSA officer is the same as your OFAC officer. OFAC's a division of the U.S. Treasury, and its purpose is to administer and enforce economic and trade sanctions against certain countries, certain terrorist organizations, and international drug dealers. OFAC is really going after the big boys and the international big boys. And really the purpose of OFAC is it's blocking those transactions. You can't engage in transactions with people on that OFAC list. So like BSA, you have to have an effective written OFAC compliance program. Like BSA, that involves a risk assessment, internal controls, training, an OFAC officer, independent testing. And again, like BSA, that program is going to really reflect the risk profile of your bank. Like I said, the OFAC requirements, it's that you block or freeze property or transactions that involve countries or entities or individuals that are on that OFAC list. You can always call OFAC. I gave you the number there if you have any questions. You know, in my experience, FinCEN and OFAC are very responsive when you call their hotline. They will respond, and you'll be able to talk to a live person relatively quickly. So if you ever have OFAC questions, you get a hit on that list and you have questions, I'd encourage you to call OFAC. The frustrating part with OFAC is that it is a very simple regulation. So to go back a slide, that's really it. You can't do transactions with these people, period. There's not a lot in the regulation about what your program has to have or this or that. You just can't have transactions with those people. And so that leads to OFAC covering everything that you do. Every transaction at your bank is covered by OFAC and could result in an OFAC violation. And that's the frustrating part, because you could have the strongest OFAC program in the world and still have an OFAC violation. There's always that risk. You can't ever have an ironclad OFAC program. Now, it's a very minuscule risk, but you know, bankers like me, like attorneys, I like to have no risk. If I can have, you know, minuscule risk, yeah, it's better than high risk, but I'll take no risk any day. And this is an area where there's always some risk, because you can't, you know, scan absolutely every transaction and completely eliminate OFAC risk. The penalties from OFAC, like BSA, is taken very seriously. It can be the greater of $250,000 or twice the value of the transaction. I did a screenshot of some penalties from a couple years ago, and these are big penalties. I mean, you know, the $619 million really is the biggest, of course, but all of these are big penalties. I mean, even $9,000 for the bank, that was probably a very small institution, and that's a substantial amount of money for a smaller institution. So these can be a big deal. You want to have a strong program to really minimize your OFAC and BSA risks. I gave you a link to the BSA Anti-Money Laundering Exam Manual out there. Again, here's the website and hotline contact information for FinCEN and OFAC. And that's it. So this is BSA and OFAC Basics, meant to give a broad overview of BSA and OFAC compliance and the pillars of a strong BSA OFAC program. I'll have another presentation out there in the webinar series on BSA updates, where I talk about mortgage loan fraud and some new guidance that has come out from FinCEN and from regulators, as well as going into some recent enforcement actions. It's always interesting to hear about those violations and see what other institutions have gotten dinged on, particularly when they're the largest institutions. So I encourage you to go out and listen to that if you have any further interest in BSA compliance. Thank you for listening.